Lawyers, what was your successful mic drop reveal moment in the courtroom? Story 1: Lawyer exposes opposing counsel's witness coaching with truthful testimony. Opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, "First thing he told me was to tell the truth no matter what." He said the lawyer is never the one who goes to jail, that he isn't going to jail for me, and if I lie, I'm on my own. Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet up on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, "I'm done with this guy." Story 2: Prosecutor gets defendant to admit offense with one question. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said, "Yes." In England, we don't say "I rest my case." Instead, I looked up at the bench, said "No further questions," and sat down. It might not seem badass, but I got the defendant to admit the offense with one question. That never happens. Story 3: Lawyer wins motion with judge's own words on expert evidence. I'm relatively junior, so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent, as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial which was to be heard after our motion was argued. That matter was also a professional negligence matter, and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the elements of professional negligence. In fact, he said, "I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence." Our matter was then called, and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Story 4: Lawyer traps driver in court with past speeding violations. My sister got T-boned by a car, causing a concussion when I was younger. Long story short, we were in court with the judge, who asked the driver if he had ever sped before. "No, Your Honor, I never speed," was his reply. The judge asked him a couple more times if he was sure, if he never sped. Ever? The driver was adamant that he never sped and never had before. A few minutes later, my sister's lawyer gave the judge some paperwork. She read it and said to the driver, "It seems that you have some past driving violations. Can you tell me what they are for?" Quote, speeding. The driver had to pay medical bills for my sister. Story 5: Witness's perjury leads to immediate not guilty verdict in assault case. Not me, but my former boss. This young kid was charged with assault, and so his future hinged on a witness identifying the kid as the person who assaulted the witness. The witness seemed credible, and of course was testy on cross-examination, but the last stupid comment he made on the stand to the last question asked by my boss, something about kid's appearance that day, was, "And his hair looked like what he has now," and pointed to his hair and the kid's hair. The witness was referring to a certain hair color/style that the kid had in court that day. On the day that this assault happened, the kid did not have that hair type. There is no way, because it was a genetic issue that developed well after the alleged assault. Like, it was too obvious. This was already documented in the record. I remember watching in the gallery and being absolutely stunned. I remember his parents sitting in front of me and suddenly sitting up straight and realizing the perjury too. I also knew my boss realized this, and as soon as the prosecution rested 0.0005 seconds later, he was getting ready to call his first witness for the kid's defense, when the judge vocally stated on the record, "No." It was a bench trial, so the judge just shook his head and declared not guilty, with no other comment. Story 6. Emotional closing argument wins child custody case. In over 16 years of practicing law, I've only really had one moment that approached impassioned oratory. I was representing a father in a child custody case. The mother had been working very hard to emphasize her point that she was a victim of domestic violence at my client's hands. She'd say it to anyone who'd listen, even in response to matters that seemed completely unrelated. She tried to argue that this was a basis for withholding their kids from him. Through deposition and trial testimony, I got her to admit to some facts that didn't fit her narrative. She and he had argued extensively, though text messages, mostly about her suspicions that he had been seeing someone else. She had neglected to take the kids to counseling or follow up with Child Protective Services recommendations. She had a notable drinking problem. And, after they had an argument, and she left the home with their kids, she had sent him a message offering to let him see them again if he paid her cash money, and persuaded him to go to a remote parking lot somewhere with the promises of completing this exchange and bringing the kids, and then, intentionally, didn't show up. That, I said to the judge in closing, is not an act of a person who fears for their safety. That is an act of malice and cruelty. It's the only time I've let a little emotion into my voice in court. The judge, who like most judges had a good poker face, didn't initially seem impressed, but I won the hearing. Story 7. Lawyer saves single mom from incarceration with last-minute motion. Very cool. Original poster. One of my more memorable court appearances involved a single mom who had walked into my office, seeking pro bono representation at a sentencing hearing the next day. She had been charged with and convicted of endangering the welfare of a child by way of a bench trial. The charges were thin at best. Her 4.5-year-old daughter had hopped the fence in her backyard and been found walking alone down the side of a busy street. Single mom had a history of substance issues and had an acrimonious relationship with law enforcement and the local assistant district attorney, but had been demonstrably clean for about 12 months. In short, single mom was found guilty of endangering the welfare of a child by the local court-lay judge for allowing her child to play unsupervised in her own backyard for about 20 minutes. The local public defender's office was well-staffed and generally provided solid representation. Unfortunately for single mother, the public defender's office had been conflicted off of her case, and she had been represented by a local solo practitioner. Solo practitioner was, possibly literally, asleep at the wheel in representing single mother. He had conducted no discovery, made no pretrial motions, etc. The pre-sentencing report, citing single mother's prior criminal history and substance use, recommended 6 to 12 months of incarceration. Incarceration would almost certainly have resulted in single mother's children again being placed in Department of Social Services custody. Single mother's children had only recently been reunited with her following a lengthy neglect proceeding which had nearly resulted in a termination of single mother's parental rights. The solo practitioner's shortcomings in defending single mother provided a strong basis to appeal the conviction, but, absent a stay of single mother's sentence, she was likely facing immediate incarceration and, at least short-term, loss of custody of her children. I literally pulled an all-nighter on single mother's case, reviewing filed documents and preparing motion papers. While reviewing the materials, I found that the lay local court judge had failed to secure a written waiver of a jury trial, as required under state criminal procedure laws. The next day I appeared with single mother, moved to relieve her former counsel, and filed a motion to vacate the conviction. After a 2-hour hearing, which included several near-shouting exclamations by the local assistant district attorney to myself and the local judge, the court agreed to postpone sentencing in order to consider the motion to vacate. 10 days later, the court vacated single mother's conviction. After another 6 months of motions and wrangling, the charge was ultimately resolved by way of a conditional dismissal. Following the dismissal of the charge, single mother relocated with her children, got herself into long-term treatment, and pulled her life together. Single mother now works as an addiction counselor in another state. She and her children have since appeared on several relatively well-known podcasts regarding overcoming addiction. While certainly not the trial of the century, I was proud to have been able to assist single mother at what turned out to be a pivotal moment in her life. Story 8. Corporate lawyer calls out opposing counsel's contract double standard. Corporate lawyer, so I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said jokingly, "Well, of course it's fine when we ask for it." Story 9. Judge berates lawyer over client's absence, learns client died. I had a notoriously mean judge berate me for 5 minutes about my client's failure to appear that day before I could get a word in to let her know that he died. Some people gasped, other people laughed. I wanted to mic drop. Story 10. Lawyer on losing end, after client sells disputed company without disclosure. I was on the losing end. Represented a guy who had bought a company, and the company failed spectacularly within months, due to a number of reasons I could attribute to the seller, and they had clearly lied about the company's finances to induce him to buy. I was suing to rescind the deal, have your lousy company back, and give my guy his money back. I laid out my huge case and thought I had it in the bag, and then opposing counsel asked my guy, "Isn't it true that you listed this business for sale a month ago?" "Yes." "And you did sell it, correct? You signed a purchase and sale?" "Yes, but he never finished paying me. He has more payments to make. I'll just give his money back when you guys give me my money back." My idiot client had me suing over a company that he had legally sold. The guy never told me. Game over on the spot. Story 11. Lawyer uses deposition to undermine contractor's testimony at arbitration. I represented a company that was sued for breach of contract by a former independent contractor. Dude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, Dude admits that he never reviewed any documents to make sure his allegations were true, never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair, even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money. At arbitration, he tries to flip his story and starts giving testimony that is the exact opposite of his deposition, so I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Story 12. Defendant's speeding experiment backfires in bench trial. Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour, and not the 67 miles per hour he was clocked at. The assistant district attorney then moved to have another speeding ticket issued because the actual posted speed limit was 50 miles per hour. Story 13. Lawyer exposes gang member's tattoo meaning on the stand. I was in a gang-related jury trial for attempted harm. Defendant was a known Crip, and the victim was a Blood. Against his attorney's advice, the defendant testified. Defendant had a tattoo on his arm that said, BK. I asked him what BK meant, and he replied with, "Blood killer." I was shocked he said what it actually meant, but in retrospect, I guess I shouldn't have been, since he actually decided to testify. Story 14. Lawyer proves relationship with photos in harassment case. Complaining witness accused my client of harassment/stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos, before and after the photo she presented. The previous photo was my client sitting on her couch inside her house, and the one after was him in her bedroom. No further questions. Story 15. Lawyer forces settlement by exposing lying witness with emails. So I call up my client's disgruntled former employee about a contract dispute that he started and that got my client into litigation. After 2 questions, it was obvious he was a clear liar. I didn't want to call him as a witness. He was prone to act unpredictably. I took down his story as we talked, which was easily proven false by documents, and which cast my client in a false and bad light. I did not tell him how I'd caught him in lies. Fast forward one day. I submit a list of known witnesses to opposing counsel, as required by the rules. Witness number 1 was the liar. Fast forward to trial. My opposing counsel calls the liar as his first witness and the liar acts like a liar. He tells the same story on the witness stand that he told me on the phone. I took emails that he wrote and entered them into evidence and proved him a clear liar. My client didn't breach the contract, the party suing did. After the liar left the witness stand, I asked the court for a brief recess. Granted. I approached opposing counsel. My client was still willing to sign on to the walkaway settlement, where no money changes hands, and no fault was admitted. We offered the deal 2 months before, and it was angrily rejected. Now, suddenly, it was accepted. Score. Story 16. Lawyer intimidates opposing counsel with empty binders in housing hearing. Corporate lawyer, but this was on a pro bono housing matter. My client just needed to not lose her housing. I was trying to get her on 1-year probation, but would agree to 2 instead of termination. On the day of the hearing, I had 6 summer associates come with me, each carrying huge binders. When my hearing was about to begin, I had them all bring them in and sit them in front of me. The opposing lawyer was a very overworked New York City housing attorney who had budgeted an hour that day for my hearing. She instantly goes, "What is this?" I told her it was my arguments. She said she didn't have the time. I started off on a 2-minute opening I had prepared, then grabbed one of the binders, and she was like, "Let me stop you there. What do you want?" I said 3 months probation. She countered with a year. Ended up agreeing on 6 months. The binders were all empty. Story 17. Lawyer wins slip and fall case with video evidence of unsafe practices. I represented a man in a slip and fall case in a national chain that grills chicken. The restaurant is not supposed to clean the grills until after they close, because it is a huge sloppy mess that involves using a garden hose after applying chemicals to remove all of the grease. The close-down process can take up to 2 to 3 hours that involve packing up the food for the next day, scrubbing the grills, mopping, etc. Even though the corporation knew this, they refused to pay more than 1 hour worth of wages after closing time. Thus, the shift managers and cooks decided that they would start the closing process 2 hours before closing, while there were still customers in the restaurant. This is really dangerous, as employees delivering food can track the greasy water into the lobby where the customers were. On one such occasion, my client slipped on the greasy water and fractured his elbow. The restaurant denied that they started closing early. I hired a private investigator who went undercover and applied for a job. He worked there for 2 weeks and secretly videotaped them starting the closing process early every day. When I played the video for the defense attorney at his deposition, he was shocked. We settled the case shortly thereafter. Story 18, lawyer traps code enforcement officer in contradiction during cross-examination. I represented some tow companies who were being targeted by a city police department. The city sent them a cease and desist letter and kicked them off the police department's tow rotation, supposedly for code violations. And definitely not the fact my client was raising a stink about the tow coordinator playing favorites with a company who was totally not giving him kickbacks. After they kicked my clients off their property, without due process, they claimed it was because the wrecked cars might contaminate a well nearby. But they never made them move the wrecked cars off the property. I had the code enforcement officer, who had been acting as the tow coordinator's henchman, on cross me. You could have forced them to move the cars off the property, right? Witness: yeah, we could have gotten an order from an administrative law judge. Me: so, if the city was so concerned with potentially contaminating the well water, why didn't you do that? Witness: I guess we didn't think about it. Me: no further questions. Story 19, client's outburst seals custody case loss. I was representing a pro bono defendant attempting to regain custody of her children. The family division attorney argued my client wasn't ready, citing her refusal of emotional counseling to avoid violent fits of rage. On cue, my client jumped up, screaming a stream of insults at the judge, yelling about them taking her kids away. I caught the opposing attorney's smirk as I ushered her out, ending any chance of winning. Story 20, law student wins exam with clever motion. When I was in law school, I had to argue a case for an exam. As the last in my class with no opposition, I opened with a motion to dismiss since the other side failed to show. The judge, grading me, chuckled and said, "Touché, counsel." Though I had to proceed, we started on a good note, and I ended up with an A, thanks to that strategic move. Story 21, cop's log contradiction leads to case dismissal. In traffic court, I saw a lawyer dismantle a cop's testimony. The cop claimed heavy rain and winds limited the defendant's window to 3 inches, yet said he smelled alcohol from across the car. Said he always writes that in his log, to remind him it was a driving under the influence stop. The judge threw out the case. Story 22, driving record exposes false testimony. I had a client accused of taking a young woman's car and crashing it, with her testifying she gave him the keys because she was drunk and, quote, would never, ever drink and drive. I obtained her driving record, which showed a driving under the influence a month after the incident. I handed it to her, saying, "Except for that one time you got caught a month later, right?" The judge found her testimony absolutely not believable, and my client was acquitted due to other evidentiary issues, suggesting she might have been driving. Story 23, turn lane arrow installation undermines defendant's claim. I trapped a defendant who testified in a deposition he had a green arrow for his left turn, and my client ran a red light. However, the additional turn lane arrow was installed 2 months after the wreck. Case settled for policy limits a week later, after this contradiction was revealed, proving his testimony false. Story 24, voicemail rant seals restraining order case. It was my 3rd month of practice in family law, representing a mom for a restraining order against her ex-boyfriend. 10 minutes before the hearing, she mentioned a drunken, ranting voicemail where he screamed threats like, "I should have harmed you." We played it in court, and after a brief recess, we settled the whole case, getting her custody, supervised visitation, child support, and the restraining order. Story 25, security tape exposes cop's lie in DUI case. I handled a driving under the influence case where a cop testified my client got in his car, turned it on, and began to pull out, denying being inside Buffalo Wild Wings. I got the security tape showing the cop at the bar, watching my client leave, then following him out. The parking lot cam showed my client barely touched the door before being stopped. The case was dismissed after proving the cop lied under oath. Story 26, bank records prove tenant's false payment claims. I represented an elderly Indian couple evicting a tenant who hadn't paid rent in 6 months. She produced undated notes thanking her for payment and a partial certified check receipt claiming recent dates. We pulled banking records showing the deposit date was a year prior. In court, the judge, realizing the tenant lied, granted the eviction, and she left mumbling, "I hate lawyers," after using a wheelchair she folded up post-hearing. Story 27. Child's coached testimony revealed by odd word. I was reviewing an interview transcript where a child made incriminating statements against my client, using an odd word. Later I watched a video of the child with their grandmother, who used the same word in the same context a week before. It became clear the child was coached, marking my first aha moment, exposing the grandmother's influence. Story 28. Landlord's email threats backfire in court. We had issues with a landlord trying to enter without notice and threatening us when selling the place. He showed up unannounced with buyers, and we sent emails reminding him of our rights, to which he responded with threats. In small claims court, we showed the judge his emails and a police complaint, leading to a formal warning, 3 free months of rent, and a smooth sale with new landlords. Story 29. Prosecutor's legal error leads to Chambers showdown. In a self-defense case, the prosecutor presented my evidence, then argued I couldn't claim self-defense without a defense, contrary to law. He finished, "I'm not making this up, that's the law." I stood, saying, "Actually, he is making that up." The judge, angry, yelled, "Counsel, in chambers!" We won on appeal, and the judge and I still laugh about it. Story 30. Cop's defiance costs him job in drug sniff case. My client was pulled over twice for unjustified substance sniffs based on associate's substance history. Cross-examining the cop, I asked if he knew prior rulings tossed his cases. He said yes but wouldn't follow them, believing judges misunderstood facts. The judge issued a scathing order, criticized his unprofessionalism, and the cop lost his job over it. Story 31. Informant's probation offer shocks court. Crossing a co-defendant informant in a trial for a very serious crime, I questioned him about prosecutors offering leniency. He denied it, but I found disclosure material showing they raised probation for aiding a first-degree offense. I lost composure, exclaiming, "They offered you probation?" He affirmed. Though my client was convicted, the jury foreperson later said they gave the informant no credence. Story 32. Judge's outburst validates fee-shifting argument. At State Supreme Court, arguing a fee-shifting case between an applicant and agency for a permit, the judge suddenly blurted, "Why as a taxpayer should I pay for the applicant's mistake?" mid-argument. I thanked her, "May I sit down?" It was a validating moment, aligning with my position, and I ended my argument there. Story 33. Bodycam contradicts cop, wins not guilty. I cross-examined a cop who witnessed a crime, using her bodycam for 3 hours. She kept insisting she saw things, not realizing I'd contradict her with video. She railed about my arrogance in the lobby, audible in court. It ended in a 30-minute not guilty verdict, and she hasn't looked at me since. A satisfying legal victory. Story 34. Client's email delivery argument fails. Representing a homeowners association, I faced a writ to invalidate a board election over an emailed nomination. The documents required it be sent and delivered. Opposing counsel showed it was sent, with experts, but I asked if there was proof of delivery. They had none, and the judge denied the writ. I looked like a hero to my client, though it was their mistake, not mine. Story 35. Judge's praise after expert cross-examination. After my first expert cross-examination at trial, the judge said in front of my adversary, "You did an excellent job." It was a wonderful moment, boosting my confidence. The judge's public praise was unexpected and memorable, marking a high point in my early career. Story 36. Hearsay objection wins parole violation case. Defending a parole violator for assaulting his girlfriend, I got evidence late. It showed she lied before about abuse known to parole. At the hearing, opposing counsel moved to enter her statement, but I objected for hearsay, citing the prior lie. The judge sustained, and with no other evidence, we won. My client was confused, but the judge noted my attention to detail. Story 37, Expert Witness Reveals Authorship. Deflating opposing counsel. We had a case where opposing counsel was cross-examining our expert witness on hydrology regarding some silt/runoff issues. Mr. Jones, wouldn't you agree that the book I'm holding is highly respected in your field and considered to be the gold standard on the subject? Witness: I am aware that it is highly regarded in my field. Would you be willing to explain, in your own words, what paragraphs 6 to 10 on page 121 is describing? Witness reads the passage word for word. Yes, I can read, but could you put this passage in your own words for the court? Witness: these are my own words. I wrote it. We were the defendants and prevailed. Story 38. Judge calls out opposing counsel's rule misinterpretation. Not a case-winning moment, but a motion-winning one, for sure. Opposing attorney was insisting that Rule A meant they could do X. I tried, multiple times, to point out Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, placed it in front of the other attorney, and said, "Show me where Rule A says X." Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, "Judge, I have nothing to add." It was pretty fun. Story 39. City's hypocrisy exposed in tow company dispute. I represented tow companies kicked off a city police department's rotation for alleged code violations, really due to their complaints about favoritism and kickbacks. The city claimed wrecked cars might contaminate a well, but never made them move the cars. Cross-examining the code enforcement officer, I asked why they didn't force the move if concerned. He said, "Because of this litigation, you have to pick your poison." I retorted, "But it wasn't your poison. It was the citizens' poison, wasn't it?" He stumbled, and I dropped the mic with, "No further questions." Story 40. Landlord's case crumbles under lack of evidence. After their witness proved to be a better witness for me, the case was essentially over. The judge asked us to wait a moment as he pulled out a calculator. He looked up from the calculator and stated he found the case in my favor and awarded me the actual costs I incurred, less the inflated damages, around $1,800, which is exactly what I expected. I asked the judge for a ruling on their countersuit, which brought my favorite "oh crap" moment of the whole ordeal. He said, "The suit against you is entirely dismissed, with prejudice, for failure to provide any evidence, testimonial or something at all to justify this eviction. Landlord is ordered to pay X amount, plus all court fees associated with filing this suit." And after the official ruling was passed, he said to the landlord, "I recommend you find a better advisor, because this guy," referring to moron advisor, "has no idea what he's talking about." It was beautiful. Story 41. Defense lawyer traps detective with undisclosed relationship revelation. Represented a woman charged with multiple very serious felonies. She insisted that in the months before the offense, she'd been seriously dating one of the detectives, who ultimately wound up investigating and testifying in her case. For a variety of reasons, I trusted this client and believed her, even though the detective never disclosed the relationship in his report. So during his testimony, I asked Detective Miller, "You had a romantic relationship with Miss Davis, correct?" He goes, "What? No," and is visibly offended. The judge looks at me like I've lost my mind. The prosecutor audibly says, "What?" I'm freaking out, because a large part of my cross and argument was focused on the bias formed by the prior relationship, and now I've got nothing, and I've lost all credibility. I try again. "Detective Miller, have you ever had an intimate relationship with Miss Davis?" As the prosecutor rises to object and the judge starts to scold me, the detective goes, "Oh yay, We've been intimate, it just wasn't very romantic. Story 42. Lawyer wins custody case with opponent's drug admission. I was involved in a pretty messy custody case. The other party was a mess, and had kept the child from my client for a few weeks. The opposing party was playing lots of stupid games, and kept requesting continuances. I requested a substance test, which the judge ordered. However, the opposing party didn't show up for it. To clarify, he did show up, he just stood in front of the toilet for literally 2 hours, and claimed he couldn't pee. I was representing the plaintiff, so the burden was on me. I called multiple witnesses that testified to the defendant's substance use. So opposing counsel decides to call their client for direct examination and asks, "You don't use hard substances, right?" That is, for the non-lawyers, a very stupid question for many reasons, especially considering his client didn't show up for his substance test. However, I fully expected the defendant to just lie and say he was clean. After the question was asked, there was a really long pause, and the defendant said, "Yes, I do both of those substances." My head almost exploded. I didn't ask any questions on cross-examination because I didn't want to muddy the waters. I won, and the child is doing great. This video does not promote illegal activity. Stories are shared for commentary and education.